I heard nothing. Good morning, everyone. My name is Tim Smith. I'm the Associate Provost of the College. It's my great pleasure to welcome you today to our Provost Forum featuring Dr. Victoria Ott. Before I introduce our speaker, the usual public service announcements, we do ask that you please silence your phones, and as usual, we are recording for posterity. And a video camera at the back of the room on this side. If you're sitting close to that, we do request that you keep your comments to a minimum because they will be also recorded for posterity, along with the illuminating words that we'll hear today from Dr. Ott. Dr. Victoria Ott, James A. Wood Professor of History, joined the Birmingham-Southern College faculty in 2004. She received a BA and an MA from the University of Central Florida and a PhD from the University of Tennessee. Her research and teaching interests have included the 19th century, the American South, and U.S. women's history. Her talk today is entitled Duty versus Dishonor: What Court Records Can Tell Us About Common Whites in 19th Century America. Please help me welcome to the stage Dr. Victoria Ott.
Thank you all for coming to my presentation. It's actually Alabama, not America. That's a Herculean task to research that. But I want to just remind everybody, if you don't know, that sabbaticals are really an important opportunity for faculty to nurture their scholarship and to make valuable contributions to their respective disciplines. This opportunity for professional development would not be possible, in part, without the continued support from our administration, namely the support from the Provost Office and our Provost, Brad Caskey. I would also like to thank my colleagues in the History Department, Will Hustwit, Randy Law, Mark Lester, Matt Levy, and Mark Shantz, for supporting me in my research and making it possible for me to spend a semester away from the classroom and from advising. My talk today is drawn from a larger manuscript project that I worked on during my sabbatical. It's a project concentrating on common white families in Confederate Alabama. My focus is on the use of gendered rhetoric to assert a sense of class identity before, during, and after the Civil War. In researching the topic, I came upon many roadblocks when attempting to piece together the experiences of this group due to the lack of first-hand accounts. The typical sources used to tell the story of non-elites in the South come from primarily diaries and letters, although those aren't very abundant, because most of the diaries and letters from the Old South in the Civil War period come from elite slaveholding families. Most common whites were illiterate and unable to have those kind of records in their lives. Church records are perhaps the closest to understanding the experiences of common whites from their own perspective, especially as churches serve not only as a place of worship, but also a place to socialize and to mitigate disputes among congregants, sort of like an alternative to civic courts. Southern elites, as well as travelers to the South, provide some accounts of common white experiences, but these, of course, come from a biased perspective. For example, D.R. Hundley, a Southern slaveholder, described poor whites as, quote, those who lived in distinct, isolated settlements and survived more on fishing and hunting than farming. As to their character, he proclaimed that they were, quote, illiterate, superstitious, and above all, lazy and perpetually drunk. Hundley's portrait of the social classes was a response to criticisms by Northern travelers and abolitionists who asserted that economy dependent upon slavery placed common whites in a state of poverty. In his argument, their status was their choice. Another source that provides a more balanced view of non-elites are the census records, primarily from the population schedules that break down communities in the state by household and records valuable information such as name, age, sex of each member of the home. They also record occupation, real and movable property values, state of origin, and literacy. Other public records, such as newspapers and government records, offer glimpses into the lives of common whites, especially, as I found during the Civil War era, Alabama newspapers recorded such events like the Mobile bread riots led by common whites in response to near starvation conditions in the city. Also, wartime newspapers and government documents record the attempts of the government to offer aid to quote-unquote indigent families as the war took a toll on their households. Yet these sources, although very valuable, do not seek out the voices of poor or common whites, thus leaving them as passive bystanders in efforts to improve conditions in the state. When I set out to uncover the story of common whites, I found that these sources, while valuable, did not do enough to demonstrate the agency of this socioeconomic group in claiming a sense of power and identity. It was actually after I read the story of the notorious Edward Isham that I started to think about court records. Isham was a poor white who led a life of drunken brawls, migratory labor, gambling, and carousing women, many of whom belonged to other men. Isham's story, which ended after he was put to death for killing a former employer, compelled me to think about how the court system could provide a place for common whites to raise their voices and assert a sense of personhood. For Isham, it was his confession to the court that unveiled a long life of crime and debauchery that ultimately caused his demise. I considered that if these kinds of sources, such as Isham's confession, can paint a portrait of poor whites, what can they tell us about common whites in general in Alabama, and also how typical was his experience? What I found was that the desire to create a better life for their family, the reliance on kinship ties, and the fierce protection of family reputation created a space in which common whites, although marginalized economically, could find a level playing field on which to exist with their aristocratic betters. And that playing field existed in the sacred confines of the court system. Men demanded the right to perform their masculine duty to provide for the protection and the security of their families, and they made this clear in the courts. Their concern with their dependents, demonstrating proper gendered behavior, also illustrated their concern for securing a respectable reputation, something valued in a world deeply immersed in notions of honor and duty. Women, too, found that the courts could offer them a level of power within a patriarchal society that favored the world of men. In particular, holding men responsible for fulfilling their paternalistic duties enhanced their domestic power in the matters of their husbands, fathers, brothers, and such. And the shirking of those duties altogether allowed them to expand the barriers of the female world into civic life by demanding protection from the community. Whites of the region who found themselves relegated to the margins of a plantation economy and political structure thus drew from the gendered rhetorical construction situated within the context of the family to assert power and identity. Now, the court records on which I relied the most were from the chancery courts, where petitions for divorce were heard. I also drew from criminal court records and pardon, clemency, and parole records found in the governor's papers. All of these sources are housed at the Alabama Department of Archives and History in Montgomery. To ensure that the subjects would classify as common whites, I cross-referenced them in the population schedules of the U.S. Census to verify their occupation and property values. Emerging from the many court cases were a number of significant themes in relation to the use of gendered rhetoric. First was a devotion to honor and public reputation, which really they kind of mean the same thing. Assertions of female power, dependence on family, and the relationship with the larger community. Before we proceed with looking at some of these themes, let's try to define my subject group. What do I mean by common whites? Really, the common whites is kind of like an umbrella term that involves yeomen who were landowners, small landowners, possible slave owners. They were independent because of their land ownership, and most of their work was considered a family enterprise. Poor whites are also included in this group. The poor whites were landless. They had limited job opportunities, low wages, oftentimes traveling around for work. The reason why they often were landless was because they were excluded from land ownership due to the price for land, as well as a discriminatory credit system. Now, for the yeomen, if they owned slaves, I utilized the form in which my colleagues in this field use when classifying somebody as a common white. Usually if they owned slaves, it was 10 or fewer, and that was a fluid status of slave ownership. Usually if they had a slave or 2 or 3, at times when economic times were good, they would have them. When times were bad, they would unfortunately have to sell them off, perhaps even breaking up families in the process. Now, certainly, they're not a part of the elite 10% of the Old South who own 10 slaves or more. So let's start examining some of these themes. First of all, as I analyzed the records of the Chancery courts, I noticed a high number of cases involving wayward wives and shunned husbands. And in those cases, they relied on the binary narrative of the good husband versus the bad wife. If a woman strayed from the marriage, it was imperative that the husband seek some means of clearing his name and demonstrate that he did all that he could within his means to fulfill his duties as a husband. Such was the case of Campbell Jefferson of Talladega County, which is situated right there. He testified in 1848 that during his marriage to Lydia Margaret Jefferson, he had fulfilled his responsibilities as a dutiful and supportive husband. In 1846, he said that that was the time Lydia had abandoned the Jefferson household, leaving Campbell vulnerable to public speculation about his ability to offer a secure, stable family. Placed on the defensive, he noted that when the couple married, he entered a, quote, matrimonial alliance in which he fulfilled his role with, quote, cheerfulness and affections and provided her with comfort and sustenance. However, he faced further scrutiny from his community when rumors began to circulate that she had moved in with another man in neighboring St. Clair County, located right there. James Franklin, likewise, another court case, faced a similar challenge to his reputation when his wife also began a relationship with another man. Nancy Franklin allegedly had, quote, voluntarily left his bed and board to take up residence with one Bennett Gibson. In fact, Nancy and Bennett, after also moving to St. Clair County, began to refer to themselves as husband and wife. In his defense, James testified that he'd been forced to, quote, live by himself at home, destitute of all domestic place and conjugal bliss, which in the married state can only result from a union with an honorable and virtuous woman, which, as James attempted to prove in the court, Nancy was not. The Chancery Court approved his petition, and the Alabama legislature believed James's assertions and granted his divorce. Now, accusations of infidelity also affected women, forcing them to use the court to protect their public reputation as well. So ideas of honor and public reputation weren't just relegated to the men, it included women as well. They had notions of honor. Sexual impropriety violated the gender agreement that wives served their husbands dutifully in exchange for the protection of financial support. In many court cases where husbands alleged that their wives had committed adultery, there were others that showed women's willingness to counter the claims and defend their reputation. Okay, perhaps one of the strangest cases I came across was that of Robert Gibson, a small farmer in Russell County who claimed that his wife Elizabeth had engaged in an affair with an adulterous affair, as it said, with one Henry Hunt in 1857. A year later, Elizabeth received a summons to appear in court to answer to the accusation. Robert had been married to a woman before Elizabeth. Her name was Lucinda, and he separated his first wife, Lucinda, to take up residency with Elizabeth. After he left his wife to assume that relationship with Elizabeth, they lived as a married couple even though they weren't legally married. He argued that he learned that Elizabeth had had an affair, after which he left Elizabeth and began the process of petitioning for a divorce. Elizabeth, however, gave a conflicting as well as disturbing response to his accusations. She contended that on the day that Robert learned of the supposed affair, he remained in the home and shared their bed, so he hadn't left her. In a strange twist, Elizabeth testified that during that day she was deprived of sleep due to caring for a sick slave boy owned by her husband. Over the course of caring for the child, she felt, quote, much exhausted from the loss of sleep and rest, and finally got some sleep after she drank a, quote, small quantity of brandy or whiskey. After that point, she fell asleep for several hours, then awoke groggy and confused. She went into the kitchen to oversee preparation of dinner when the female slave of Henry Hunt, the man who her husband accused of having an affair with, urged her and entreated her to drink another spoonful of whiskey or brandy. Elizabeth claims that after drinking that, quote, her head began to nod and she became utterly insensible and had no recollection of walking from the kitchen to her bedroom. Henry Hunt was allegedly there at the home that evening, which counters the claim that he had left his wife after learning of the affair. In a bizarre twist, Elizabeth leveled a surprising accusation that when she woke up the next morning, her husband was in her bed with her and she had the ominous feeling that she'd been drugged. Elizabeth's testimony, in part, served to counter the claims that she was an adulterous wife. Rather, she asserted that she remained faithful and implied that perhaps Robert was engaging in illicit activities. She argued that Robert did not treat her with affection and kindness, those were her words, even though she had been, quote, an obedient, constant, and faithful wife. In fact, she alleged that he had threatened to kill her and that he would, if he could not get rid of her. His reasoning, she stated, was that he, quote, intended to have a third wife, and this was all a horrible plot. In most cases that I reviewed, the defense of honor through the court system sometimes came down to the case of he said, she said, who wronged the other the most. To restore one's reputation and provide material support, common whites found it important to convince the courts that an unbelievable wrong had taken place. In 1833, David White of Wilcox County filed a petition for a divorce from his wife, Jemima White. The couple had been married for 30 years and produced 8 children. Yet, as David claimed, Jemima, quote, has never been a dutiful and obedient wife. She has left the bed and board for the space of 4 years with the intention of abandonment. He further charged that she continued to cause him, quote, injury by incurring debt that he was obligated to pay. Jemima returned the accusations with her own charges of David's failure to live up to his masculine duty and, in her estimation, had caused public embarrassment to the family. She claimed that over the course of their marriage, that David had engaged in upwards of 20 extramarital affairs and had fathered a child. Jemima further accused her husband of boasting, quote, in the presence of their mutual children and grandchildren, that he had had improper intercourse with 20 women, some of whom were married women. When she attempted to confront her husband about his actions, Jemima testified that he left her and left her entirely destitute. She told the court that she had no intention of divorcing David and that, given the opportunity, she would still fulfill her domestic duties despite the extramarital affairs. Her counter bill actually was intended to have the courts ensure that David would provide for her material support rather than to offer a counter petition for divorce. Before Jemima could petition for spousal support, though, placing David in the position of having to defend his honor, he presented a bill for divorce, claiming that his wife had abandoned him. Regardless of the claims, nobody really believed much of what they said, and the divorce petition was dismissed. The role of a father, when we talk about the other ideas of honor and public reputation, the role of father plays a big part in that, and I noticed that in some of the court cases that I examined. Family informed a man's masculine role and validated his standing in the community by his ability to support his dependents. In the case of common wives, the primary dependents were the wife and children. Yet when a woman found that she could not bear children, she placed her spouse's masculine identity at risk and therefore created grounds for a divorce. Malcolm A. McKinnon of Talladega County, for example, sought a divorce from his wife Sarah, who he had married in 1845. In 1849, just 4 years later, he alleged that, quote, he has never been able to have sexual intercourse, and blamed it on Sarah's, quote, apathy and physical inaptitude for the marriage state. In the paternalistic culture of the Old South, the role of father held a special meaning for men, as I mentioned. It meant the continuation of family lineage and required men to exercise their role as protector and provider, the head of the household. For those of modest economic means, like Malcolm, children also helped to expand the labor force on the farm or in the family business. Malcolm actually did not intend to impugn the reputation of his wife, merely to show her inability to perform her quote-unquote marital duties. He expressed a deep respect for his wife and remorsefully over the defect, as he called it, of her inability to achieve intimacy. He said that that inability had created, quote, a relationship of gloom without a single hope to light up a dim and cheerless future. Yet Sarah's inability or unwillingness to be intimate with her husband, we don't know what was the cause, placed social pressure on Malcolm to end rather than to remain in the marriage. Surprisingly, though, the court did dismiss that bill. Another really significant theme, especially to my larger manuscript project, was the assertion of female power that I noticed in many of the court cases that I examined. And by the way, the ones that I'm presenting to you are just the tip of the iceberg. I have studied several of these over the course of a few years. But the assertion of female power in the court system I found to be very interesting, as it gave a voice to a group of women that usually don't have a strong voice in the canon of historical research. I noticed, first of all, an overwhelming number of women abandoning their husbands. And that led me to the question, why? Historian Victoria Bynum found, quote, a familiar pattern of escaping one man by taking up with another, and that existed among non-elite white women. As seen in the cases of especially poor women, the intersections of class and gender constrictions left them with little power over their private lives. In searching for the means to escape a horrible marriage, the most common way was to enter into a new one. In a patriarchal world that made it difficult to legally sever a marriage, coupled with the lack of financial resources to function independently of marriage, adultery with the intention of starting a new domestic partnership was their only recourse. Thus, most cases of abandonment involve some form of infidelity on the part of the wife. As a result, many of the cases involve men seeking to account for their wives leaving. In other words, they don't want people to think that their wives left because of them. For example, Thomas Williams of Russell County sought a divorce a little over a year after his marriage to Eliza Williams. He testified that he had provided her with all the necessaries and comforts of life suitable to his financial means. Yet he claims that, quote, without any good cause, she had voluntarily abandoned the bed and board and still remained separate and apart from him. Eliza actually had moved all the way to Georgia at that point of the trial, and she refused to actually show up for the court case. Having proven that she had left the marriage and that she had done so without cause, the court granted the petition for divorce. Now, to protect masculine honor in the face of abandonment, men often attacked their wives' reputation, relying on the popular narrative involving prostitution and/or illicit sexual activities. For example, Byrd Forsyth portrayed himself as the upstanding, proper husband who did all that he could to provide for his family and his wife Mary. The couple married in 1854 and moved from Georgia to Alabama. Byrd contended that when he married Mary, he believed her to be, quote, a virtuous woman. He charged that after their wedding, she proved herself to be, quote, faithless to her marriage vows, that his wife had engaged in criminal sexual intercourse with diverse persons. Those were his words. He further told the court that his wife, since filing a petition for divorce, was quote, living the life of a common prostitute. And in demonstrating to the public court that he served his role properly, while his wife turned to infidelity, it was not his fault that the marriage had failed, but rather a moral failing on Mary's part. Another point that came up when I looked at this pattern of assertion of female power also came in cases of escaping domestic violence. Women like to turn to the courts to empower themselves against violent relationships. The patriarchal culture provided little protection for women against physical violence. For common white women, the necessary action to leave an abusive situation was to seek a divorce or take up with another man. For common white women, yet successful petitions for divorce meant that a woman needed to prove that she had lived up to her feminine roles and that her spouse had failed at his. Women did not intend to undermine or challenge the patriarchal system by leaving the marriage. On the contrary, they worked within the system then when seeking a divorce, thus reinforcing masculine privilege. In other words, when husbands failed in the masculine duties, it was the responsibility of the state through the courts to protect women. Now, legal authorities typically view domestic violence as a private matter, leaving it to members of the household to resolve the issue themselves. A social structure that privileged men as the paternal figure in the home also acknowledged that husbands, at times, would need to punish their dependents, including their wives, as long as they refrained from excessive force. Of course, alcohol tended to emerge as one of the catalysts for abuse. In the case of Mahala Mansell, she filed for a petition for divorce after nearly 10 years of marriage. Her husband, John, was a small independent farmer from Bibb County with a small amount of property and a few slaves. Mahala testified that for some time after their marriage, the couple lived together harmoniously, with a few setbacks due to John's bouts with the occasional, quote, intemperance after consuming liquor. She contended, however, that the intermittent drinking had grown into a confirmed habit that led to cruel behavior toward her and, quote, a total disregard to all the duties of a husband and a father. He often threatened to kill Mahala and, quote, degrade her in the person of his servants. John's behavior reached a violent climax when one day he, quote, violently assaulted her and beat her and bruised her, leaving her with marks that lasted for several weeks. Over the course of the marriage, the couple had 4 children, the youngest being 9 months during the point of the court case. As a result of John's alcoholism, he left the family destitute and in need of financial relief. Mahala argued that due to her children's dependency on her for support and the failure of John to meet his responsibilities as a virtuous husband, the court needed to exercise their authority on her behalf. John, of course, attempted to defend against the label of an alcoholic and abusive husband as it threatened to tarnish his reputation. He admitted to being intoxicated on occasion, but denied the allegations of, quote, cruel and intemperate treatment. More importantly, the charge that he neglected his obligations as provider seemed far worse And he claimed that he was never drunk to the point to make him, quote, neglect his business or be unable to attend to it or forget his duty to his family. Rather, John blamed Mahala, and especially Mahala's mother and her meddling in the marriage as the source of their problems. He testified that on one occasion he left for a week to earn money painting a house in Perry County. During that time, Mahala's mother, he contends, said to her daughter that she would not live with a man who would leave her for a week at a time. Much to his surprise, the mother further attempted to harm his reputation by accusing him of visiting slave cabins for sexual relations with servant women. In an attempt to further deflect the blame, he argued that the incident during which he struck Mahala was his attempt to restrain her after they engaged in a verbal fight that led to her attacking him. He said that, quote, one morning she refused to have breakfast prepared for him, and that she claimed she would, quote, never prepare another meal for him. At that point, he claimed she immediately made at him for a fight. He caught her and held her without attempting to injure her in any way until she called a servant woman to assist her. Then he struck her twice, not violently, about her neck, and her neck was somewhat scratched in his attempt to hold her. Those were his words. According to John's account, he was the innocent victim of Mahala's disregard for her obedience to him and failure to trust him. And he, quote, always loved her and most devotedly. Yet Mahala's accusations of abuse proved stronger than John's attempts to redirect blame, and the court granted her petition for divorce. While the courts viewed domestic violence as a private matter, they were willing to step in to protect women facing extreme cases of abuse, such as in the case of Zelpha Reach of Bibb County. She endured extreme verbal and physical abuse from her husband, Jeremiah. She stated in her petition for divorce that, quote, he failed in the performance of almost all of his duties as a husband and has frequently treated her with great violence in a cruel and barbarous and inhumane manner. The abuse became so severe that he often left her with, quote, marks and bruises. She pleaded with the court that she did nothing to warrant his violence. Rather, she had performed all of her proper marital duties. But still, Jeremiah had threatened to destroy her life, as she said. He also, at one point, forced her to leave the home, which she had to retreat to her father's house. She returned to Jeremiah, after which the abuse he started again, claiming that he beat her with his fists, rods, and pulled her hair. After that final incident, Zelpha returned to her father's home and petitioned for a divorce. Of course, Jeremiah tried to protect his reputation because he saw it at stake. It was at stake, and he responded to Zelpha's claims by blaming her. Zelpha, according to Jeremiah, lacked the virtue of a good wife, even when he tried to forgive her for what he said was an affair that she had engaged in during their marriage. Yet his hopes were, quote, soon to be changed to dread and bitter disappointment after he gave her the most kind and humane treatment. He went on to claim that Zelpha disregarded his feelings and had added insult to injury by, quote, intentionally defiling her finger and rubbing it on his nose. It was at this point that Jeremiah testified he struck Zelpha though in great moderation, believing that such abuse was his imperative duty as a good husband. To underscore his accusations of Zelpha being an improper and immoral wife, he went on to claim that she had also contracted, quote, a loathsome disease. Now, the court had medical professionals, I assume it was probably women under the direction of a doctor, to actually examine Zelpha, and they found no proof that she had a disease. And in fact, the court finally concluded that she had endured too much abuse, that although a husband did have the right to punish his wife, he shouldn't do it as to endanger life or health. Now, women also asserted a great deal of economic power in the court system. For an example, in a society that left wives to the mercy of their husbands, many women turned to the courts to seek protection from their husbands abandoning them, as women, of course, depended mostly on their income. Even if a woman did work for some sort of wages, the inequality in pay between men and women meant that she could find herself destitute and unable to support her children. Antonella Green filed a petition for divorce from James Green, both of Wilcox County. As the petition stated, Antonella claimed that James had disinjured the bed and board for a span of 3 years, and that without a formal divorce, she was not free to remarry, thus reducing her ability to seek financial support from another man. Other women sought economic protection from their husbands and their bad choices. When Gulliford Olive of Russell County filed a petition to divorce his wife, Isabella Olive, he claimed rights over her estate that she had brought into the marriage. He claimed that she abandoned the home even though he, quote, endeavored to be the best husband of his ability, to discharge all the duties and obligations in the marriage. However, by the time Gulliford filed the petition in 1853, the couple lived separately. Just 4 years later, Isabella went through the court system seeking protection of her property from Gulliford, who was still trying to take it away from her. She cited that she had some land and a few slaves, and that he had very little property, and what property he did have, he mismanaged. Rather than rule in favor of the male, the court recognized that Isabella had a right to maintain her own property separate from her former husband, and actually sided in her favor. In other court cases, the authorities recognized the financial dependency of women and required husbands to provide some payment towards their wives, something like akin to alimony. So by calling on gender conventions, especially the ideal of female dependence, they actually asserted a sense of power. In essence, rather than challenging the gender norms, that women actually, through the courts, use those norms to their advantage. Now, another theme that I found really significant, and other historians looking at other southern states, such as North Carolina and Georgia, found that the reliance on family was very important for common whites because they didn't have the financial resources that elites had. So family was doubly important to them. And so family also, in looking at the court cases, became a source of not only economic support, but a source of protection and solace when members found themselves in trouble. Huldah Johnson of Bibb County turned to her family when her husband Spencer became physically and emotionally abusive toward her. The couple married in 1840 and had 2 daughters over the course of their marriage. In 1852, Huldah testified to the Chancery Court that soon after they wed, her husband treated her with, quote, great indignity and cruelty that lasted through the course of their marriage. She claimed that during fits of jealousy, Spencer would, quote, charge her with having illicit intercourse. He would inflict corporal punishment with a switch and by choking her. After the first incident, Huldah escapes to her father's home, where the father unfortunately actually convinces Huldah to go back to her husband, Spencer. Spencer grew abusive again, actually started denying paternity of their daughter. She then leaves and goes back to her father's home, but then realizing that her father couldn't afford another mouth to feed, goes back to Spencer. By that point, Huldah was pregnant with their second child, and actually Spencer recognized the paternity of that child. However, it seemed that all was not going to go well in their marriage, and in a fit of rage, while Huldah was pregnant, he, quote, pushed her out of the bed and threatened to kill her. It was at this point that Huldah went back to living to her family. However, sadly, as in the case of many scenes of domestic violence and living in those kind of situations, Huldah went back again to Spencer and remained there, and we don't know what happened to the couple after that. Amanda Dortch also turned to her family for support when her husband left the home The couple married in 1839 and moved to Bibb County just a few years later. Shortly after the move, her husband, James Dortch, abandoned the home and moved to North Carolina. And Amanda went before the court to seek a divorce from her husband. Like many women in the courts, she had a male family member address the authorities on her behalf. And it was actually her father that testified for her in saying that she had, quote, faithfully and affectionately discharged all the duties of a wife. And that, in fact, it was James Dortch who had taken all of the money from the family and even money that Amanda had earned by her, quote, industry and had left. Amanda actually goes to live with her father, and she remains there as what she called her proper home. The final thing that I found when examining these court records was also the relationship with the larger community. And this I found that many of those who were incarcerated from crimes ranging from thievery to manslaughter turned to the community for help in requesting pardons, parole, or clemency. Historian Scott Colcature notes in his study of poor whites in North Carolina that community members were actually willing to come to the assistance of those on trial or in prison and would be, quote, treated with consideration if the community could, quote, recognize shared bonds of personal character or appreciate circumstances that they judged to mitigate the crime. In other words, elite members of the community or even those who were well off would be willing to speak on the behalf of common whites if they recognized that perhaps there was a reason for the crime being committed or that they could identify with the person incarcerated. And so what Colcature found in North Carolina is the same thing that I found in Alabama. Community members identified with men on trial or convicted who appeared to be acting honorably in self-defense or whose role as family provider was in jeopardy. For example, Thomas Adams and his son, both of Lauderdale County, landed in jail after a physical fight. Now, the record is unclear whether the father and the son were actually fighting with each other or they were fighting other people together. Regardless, Thomas, who was the only record that I could find of this case, could not pay the court costs, which amounted to $50. And the petition to have the costs waived stated that while Thomas was guilty of the fight, there was, quote, no damage or blood drawn. And being a man of modest financial means, the petitioners argued, Thomas could not afford to be away from his family of 13 children, all of whom, quote, depended entirely on his exertions for their support and maintenance. Also, I found some other smaller cases, petitions, like in 1820 in Tuscaloosa County, court convicted a man named Daniel West of assault and battery and fined him $100. But there were supporters from the community who signed a petition asking for the court to waive the fine, claiming that he was a peaceable and orderly citizen. In the case of James of Florence County, and some of these, I want to mention some of these records that's illegible. You can't read necessarily what the people are reporting because of the antiquated nature of the documents or just the really bad handwriting of the person that's recording these things. So for James, I could only get his first name, but I did know that he was from Lawrence County. The community actually came to his defense after his conviction of manslaughter in 1825. A man in the community accused James of circulating a rumor that he had stolen corn. The man, along with two companions, confronted James at a corn mill and demanded that he fight them in order to restore the man's reputation. James tried to avoid the fight, as the petition went, but eventually had no choice but to battle the man. In the course of the fight, James had gotten the best of his accuser and, quote, several times called on the deceased to cry enough, which is like crying uncle. Unfortunately, James ended the fight by killing the man, and authorities took him into custody. After his conviction, however, over 200 citizens signed a petition on behalf of James, asking that the governor release him, citing that he was a good man and the son of a soldier of the Revolution. They argued that James had little financial means, a large family, and as a result, the courts did waive the fine that he could not pay. They also believed that James had followed the right code of conduct in a physical conflict that was intended to restore honor, and that unfortunately the man had lost his life in the process. The community rallied around James and insisted that he be freed from paying the fine and allowed to continue supporting his family. So, what does all this mean? If we rely just on these stories that I told you today, one walks away believing that common whites in Alabama lived a private life somewhat akin to a bad Jerry Springer episode. But utilizing the other sources, the one I mentioned earlier, diaries, letters, church records, etc., in combination with these court records, we can learn a more nuanced and richer story of their lives. The stories found in these sources provide the foundation on which, of course, I base a larger narrative of the intersection of race, class, and gender in the lives of Alabama's common whites. Out of this intersectional nature of their experiences emerges a societal identity and a sense of power rooted in the popular ideals of masculine and feminine behavior. In essence, we see that rather than standing on the sidelines of Alabama's past, they situate themselves into the mainstream of society, ultimately finding themselves a sense of place and of purpose. Thank you. Any questions? Yes, Dr. Hubbs.
I just wanted to thank you for carrying on a tradition begun in 1949 with the publishing of Plain Folk of the Old South by Frank Lloyd Owsley.
Yeah.
Like yourself, Owsley began his career teaching here at Birmingham-Southern.
Oh, wonderful. That's inspiring. Some more questions? Comments? Yes, Dr. Tatt.
Just practical things. How did common whites afford the court costs, and did they have to pay lawyers? Was any of that part of the
I didn't find a lot about the costs to file a petition, and that's, of course, something that, as I'm going to be working on this still in the summertime, I'm going to fill in those little gaps there. What I understand is that they relied on community assistance. And in the cases of, like, some of the women I mentioned who were escaping bad marriages, they turned to their families to help them. Their families had very little means to file those petitions, but usually they would get somebody from the community to file it on the woman's behalf. So, yeah, I haven't seen receipts or anything like that to kind of give me any indication, but I'm working on that. Because I think that's important to know, that they're willing to, if they're asking their family for this assistance, that's a big sacrifice for them. Yeah. Some other questions or comments, insights? Yes?
We're talking about the nuclear family, and that's would be the basic unit, and also honor culture. And something really interesting to me is typically we've got honor culture. It's not the nuclear family so much as the extended family.
Right.
And then with rights and obligations culture, for middle class culture, sort of so then things change morality wise. Is this a hybrid culture then? Is this honor culture that honors the extended family and the nuclear family? Is this sort of in between? Or
When you say extended family, you mean like the larger family, or do you mean like extended family, like the community that's wouldn't have any blood ties to the larger community?
it can be both.
Both.
I mean,
Yeah.
The concept is to divide the nuclear
It
family,
is.
you have the clan unit.
Right, right.
Is this an in-between, or is this an either or?
It's sort of varying them both. So when their wives, for example, would go to court and say, my husband was a bad father, the first concern is, I've been insulted, and I need to restore my reputation to the larger community and for themselves. Some of the other things that I've studied that I didn't include, because this is, again, part of a larger manuscript project, is the idea of what historians call primal honor, where instead of engaging like in a formal duel that elites would do in a public forum, like the example of James, who a man said he'd started a rumor that he'd stolen corn. Well, that's an affront to his honor. So those men weren't fighting with pistols, but they were publicly fist fighting with each other, and that was the way that they restored honor. So if they weren't going through the courts to do that, where I found a lot of slander cases and things of that nature, they were doing these public demonstrations. So it was both to, the family became sort of the conduit into maintaining a reputation, identity in the community.
Do you think it's getting more legalistic and less honor-like over time, or do you see what we're finding?
That is really, I noticed that, yes, there is more use of the court system. The last two chapters of the manuscript deal with the post-war period in Alabama and common whites then, and I am still finishing up the research for that. So I don't have a lot to go on. But yeah, I think that most of the sense of the honor culture, like the dueling culture, that sort of thing, that fades away after the Civil War, people turning more to the law to deal with that. I'm not sure how much in that sense of restoring that masculine honor through fighting is how much it still goes on. So hopefully I'll find out something. Again, it's hard to uncover their story because you have to be creative. That's why liberal arts education is important, right? Because you have to be able to pull from all different directions to come up with a story of these people's lives. Yeah. Dr. Law.
That's actually my question. I think that the material is fantastic. Anything you can do to get the voices of the people into your story through research is wonderful. That's my question. To what degree are the actual words that you're quoting here? That's I love that you quoted sources. Is there any way to know if those are the actual words that the people spoke, or to what extent? If those words are being massaged by the people who are writing. Are any of these documents from sources that the petitioners actually wrote, or are they being transcribed or, I guess, interpreted to make it sound formal and legalese, formed all the other things?
Somebody is recording their testimony. Like with Isham gives this great detailed confession, which is basically his life story, and he's telling it to his lawyer. And so we have to understand that the lawyer's probably taken out some of that bad language, not using the dialect that they would use. If they were writing these themselves, they wrote phonetically a lot, and so we would see that, and we're not seeing that. I'm not seeing that in the testimony from these people. I do know that there's a lot of corroborating testimony. So and the courts would dismiss the bill if there wasn't enough to corroborate, say, a woman's claim to domestic violence. So, yeah.
I wanted to get back to Joey's question about honor. Is it possible that the court system itself, during the you covered only the anti-development.
Just for this talk.
For this talk. Do you see an increased reliance over the course of the years, let's say from the 1820s, you had some cases in the 1820s, some cases in the 1850s. Is this an attempt to, using the court, an attempt to restore honor, irrespective of duels, irrespective of fighting?
Right.
And is it increasing over time?
It's sort of in addition to. Yeah, I mean, I've noticed a lot that these kinds of cases, they don't decline in the historical record. So Yeah, I mean, they continue to turn to the courts. It's just I haven't quantified how much they're doing that in the post-Civil War period versus the pre-Civil War period, the antebellum period.
But even within, is it a steady stream? Is there a moment where it starts to emerge?
It really is sort of a steady stream. Yeah, yeah. So, let's see. Jackie.
In the case where like the divorce won't be granted, is custody of children discussed at this time?
Right. I would say, how would you answer that question? Because we talked about that in class. This is about the time that the courts are starting to recognize that custody should go to the wife. And so in some of these cases, the child stays with the father. In some other cases, they stay with the mother. Most of the time when it's the case of the husband abandoning, there's no issue. She's got all the children. And if she has another household to go to, she would take the children. But I did run across cases where the husband said, okay, if she wants to go off with another man, that's fine, but I want my child or my children, and so would ask the courts for that. And the court usually would grant it to the husband because it's assumed he could support them, right? So, but it does start changing around the 1840s, and that's part of the first wave of the women's movement, is to give women more rights to child custody. So yeah, it is starting to change, you know. By the 1860s, more women are getting custody of their children outright. That we don't know. That's hard to tell because that's after the court case is done, right? So we don't really know, and that's the frustrating thing. It's like this: I get this flip in time where I can hear what they're saying, and then I want to know where did it go. And so that's what I'm rushing to. The census, the population schedules, which give us that great detail, and it's still not enough, you know. So, yeah, that's a good question. Oh, yeah, sorry, Scott.
Yeah, so in some of my research into Alabama's logical history, there's differences with the states that were opened up to settlement much earlier, like states adjacent to Georgia. And I'm wondering if they're, because of families having longer time span on the landscape and maybe larger extended families in the immediate area, in say states like Georgia, South Carolina, if in Alabama there's might be differences in the system to settle issues versus say in states that have been settled for much longer.
Right.
So I'm wondering if
actually, that's part of the thesis for this is a bulk of the research for the first chapter of the manuscript, and that's actually the thesis of the manuscript of that chapter, is that because Alabama still is like a frontier sort of like state, because of course it's our bicentennial, right? So it was state by 1819. Even by then, it's still very, very frontier-like. And so, yeah, there's this sense of a level playing field, even though it doesn't really exist between the classes. There's a feeling that of equal opportunity. And so I felt like when it came to especially cases for divorce, that women were more likely to turn to the courts for protection because of that isolation, feeling being on a kind of frontier conditions, rather versus in South Carolina, where it was much harder to get a divorce. The divorce laws were more liberal in Alabama than they were in those more established states. So yeah, absolutely. Oh yeah, sorry, we gotta wrap it up. So thank you all for coming. I really